Hello and welcome, and thank you for joining us for today's webinar. Before we get started, I have a few housekeeping notes. First, for the benefit of all participants, attendee lines have been muted. So should you have any questions that you'd like to submit during the event, you can submit them through the question and answer space. If we can't address your question during the webinar, we'll follow up after the program. Second, please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. And note that Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. Unfortunately, credit is not available for joining via mobile device. Third, and finally, one other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, then you can just disregard this. And so again, welcome to our webinar on the first hour of which will be about litigation tips for in-house counsel. And today you'll be hearing during this portion of the webinar from Amiana Stovall out of New York, Megan Howler out of Indianapolis, and then me, Alex Good, also out of Indianapolis. We're all litigation partners with Dentons, and you can find out more about our specific areas of practice and experience by reviewing our bios on our firm webpage. Got a agenda here for you. Today we're going to cover a number of topics we think are relevant to in-house counsel that relate to litigation. We'll begin by talking about corporate privilege, and then we'll talk about litigation holds, document collection and retention, the role of counsel in the discovery process, tips for reducing and managing costs, particularly associated with litigation and discovery. And finally, if we have time, we'll have some question and answer. And with that, I'll turn it over to Amiana to talk about corporate privilege.
Thank you, Alex. Well, when it comes to representing corporations or other business entities, the privilege, of course, belongs to the entity. Because, however, the individual directors, officers, and employees of that entity necessarily speak on its behalf, as in-house counsel, it's important to keep the scope of the corporate privilege in mind when you're communicating with each one of those constituents. Since an in-house attorney is likely to find themselves wearing a variety of different hats, it's easy to find yourself in situations where the privilege lines become blurred. So what we're going to focus on here today is understanding where those lines are and how to maintain those lines to preserve your corporate client's privilege. We're also going to talk about the importance of issuing Upjohn warnings to corporate employees interviewed in the context of internal investigations so that everyone involved in that interview, including the employee, is on the same page with respect to who holds the corporate privilege. Now, the corporate privilege under Upjohn. Corporations will undertake internal investigations at the direction of senior management or the board of directors or some committee of the board, and it's usually fairly straightforward that communications with those individuals are covered by the corporate privilege. Under the Supreme Court's holding in Upjohn versus United States, the corporate privilege was expanded beyond this control group to every corporate employee, regardless of status, provided that the communication is intended to obtain legal advice for the company. The communication involves matters within the employee's corporate responsibilities. The employee is aware that they are being questioned so the corporation can obtain legal advice. And the communications are considered confidential when made and are kept confidential by the company and the employee. Only by meeting each one of these factors will information sent to or received from an employee be protected by the corporation's privilege. If any one of these factors is absent, the company's privilege is at risk. Now, as in-house counsel for a company, you're likely fielding a lot of different questions with all sorts of company information coming across your desk. So it's important that not only you as in-house counsel understands what is and is not covered by the corporate privilege, but company employees should also have an understanding of the limitations of the corporate privilege when they're sending emails and other communications internally. First, underlying facts are never protected. Facts are facts, and that cannot be made subject to the corporate privilege just because they're put in an email or a memo and sent to in-house counsel. Similarly, business advice is also not protected, whether it's going to or coming from an attorney. But where it gets complicated is with dual purpose communications that commingle both business and legal advice. Whether or not such a communication is protected is actually going to depend on what jurisdiction you're in. In the Ninth, Second, Fifth, and Sixth Circuits, before the attorney-client privilege will attach, the primary purpose test is applied, which requires a showing that the primary purpose of the communication was to obtain or provide legal advice. The DC Circuit applies a significant purpose test, which is arguably a little bit broader than the primary purpose test. It requires a showing that just one of the significant purposes of the communication was to obtain or provide legal advice in order to be considered privileged. And finally, the Seventh Circuit, at least in the tax context, doesn't recognize a privilege for dual purpose communications at all. So any such communication will be subject to production regardless of any privileged information that might be woven within it. The Supreme Court had the opportunity to resolve this circuit split in the matter in re grand jury, but in 2023, it removed the case from its docket. So the split remains, creating uncertainty as to whether a dual purpose communication is going to be protected, especially for companies that have a presence in multiple jurisdictions with different approaches to the privilege. And keep in mind that redactions are not a backstop. If it's determined that the legal advice is not the primary or significant purpose of the document, depending on what court you're before, you could be ordered to produce an unredacted copy. Given this uncertainty, as in-house counsel, you should be sensitive to commingling business advice with legal advice. Likewise, you don't want to commingle regulatory or HR investigations with internal legal investigations because that will also put the corporation's attorney-client privilege at risk. Finally, you want to make sure that you're not sharing legal advice with anyone at the company who does not need to know that information. And when you're sharing legal advice, you should be clearly marking those communications as privileged. Now, when it comes to Upjohn warnings, in-house or outside company counsel interviews employees in the context of an internal investigation. In order to maintain that privilege over the record of that interview, it's critical for counsel to issue what's been known as an Upjohn warning to the employee. The Upjohn warning provides a dual purpose in that if a regulator or other outside entity demands access to the employee's statements, the issuance of an Upjohn warning will confirm that the discussion was had in an effort to gather information necessary to provide legal advice to the corporation and is therefore subject to the corporation's attorney-client privilege. But the Upjohn warning also informs the employee that the privilege belongs to the corporation, not the employee individually. And as a result, the corporation can share whatever is discussed with the employee during that interview with third parties if it chooses to do so. The goal when issuing an Upjohn warning is to make it as understandable as possible so that no matter how sophisticated or not an employee is with respect to making disclosures, they understand, first, that the counsel represents the corporation, not the employee. Second, that the employee is being interviewed in connection with an investigation in order to provide legal advice to the corporation. Third, that the interview is protected by the corporation's attorney-client privilege. Fourth, that because the privilege belongs to the corporation can waive that privilege and disclose any information it receives from the employee during the course of the interview to third parties, including the government, without the employee's permission. And fifth, the employee should be told not to share what was discussed during the course of the interview with anyone, including other employees, in order to maintain the privilege. The Upjohn warning is important since a corporation facing a governmental investigation might be motivated to waive its privilege if the employee's information provides it with the opportunity to cooperate with the government, potentially in exchange for leniency. But from the employee's vantage point, without getting an Upjohn warning, the employee could be unwittingly waiving their own Fifth Amendment rights, especially if they mistakenly believe that the corporate counsel is also representing them individually. Because of the potentially high stakes involved, there are a few things that you should remember when you issue an Upjohn warning. While there are no particular magic words required for a proper Upjohn warning, it's essential that each of the elements we just discussed are included in the warning. The best practice is to script the Upjohn warning in advance, keeping it as simple and as straightforward as possible to avoid any confusion. It should also be given, obviously, before the interview begins. Giving it at the end of the interview or not at all comes with serious risk to the company and the employee. Not only can the company lose its privilege over the interview, but the employee will have very little recourse after the interview and once essentially the cat is out of the bag. One of the seminal cases in this area is U.S. versus Rule out of the Ninth Circuit from 2009. Rule was Broadcom's CFO and was interviewed by the company's counsel about the backdating of stock options. Thereafter, Broadcom's lawyers turned over the interview record to the company's audit committee and ultimately the government. Rule was subsequently indicted in connection with the backdating scheme, but claimed that his statements to Broadcom's lawyers should have been suppressed because, one, he did not receive an Upjohn warning, and two, those statements were covered by the personal attorney-client privilege since Broadcom's lawyers represented him individually in two civil actions involving the same backdating allegations. Although the district court agreed with Rule, the Ninth Circuit reversed. It concluded that even if Rule didn't receive an Upjohn warning, his statements to Broadcom's attorneys were not protected by an individual attorney-client privilege because they were always intended to be disclosed to third parties, in particular, Broadcom's audit committee. In coming to that conclusion, the court pointed to the CFO's sophistication as a senior executive as evidence that he was aware that the information would be disclosed to the audit committee. As in-house counsel for a corporation, the lesson here is that clarity going into these interviews is essential. It's certainly not unusual for a company's lawyer to also represent individual directors, board members, or executives in various proceedings, but you'll want to avoid a situation like that in Rule where the lines between those representations become blurred. That could lead to having some uncomfortable conversations with top people at the company, but there are discussions that need to be had in order to keep focused on the interests of the company. Finally, you're going to want to make sure that there's a written record of not only the Upjohn warning, but any conversation about that warning, including any questions and answers between counsel and the employee. In creating this record, you'll also want to note the employee's acknowledgement that they understand the Upjohn warning and that they are prepared to go forward with the interview. That said, while jurisdictions like New York and California make plain that employees must receive very clear Upjohn warnings, there's no jurisdiction that requires the acknowledgement to be in writing. The most effective way to memorialize the interview is to do so in a memo or an email that includes corporate counsel's recollection and mental impressions. Not only will you be further ensuring protection under the corporation's attorney-client privilege, but also under the work product doctrine, since the memo will be reflecting opinions, conclusions, and other theories developed by corporate counsel during the context of the investigation. Now, once you give an employee an Upjohn warning, the employee will often have some questions. This can get a little bit tricky since the information you need for the investigation, you need to get the information for the investigation, but you also simultaneously need to make the necessary disclosures to the employee. This can be a very delicate balancing act, especially since you're probably not aware until after the interview if there's any adversity between the interests of the employee and the company. One thing that you can do to manage the employee's initial concerns and put them a little more at ease, particularly when you're dealing with lower level employees, is to simply let them know that the Upjohn warning is something that all employees being interviewed in the context of the investigation are receiving. You do, however, want to be ready to field questions from the employee, the first of which is usually, do I need my own lawyer? Here, you have to inform the employee that you simply cannot advise them on that one way or the other because you just don't have enough information yet to make that determination. But you do want to reiterate that they have a right to separate counsel if they wish. In the event that an employee's interests are clearly adverse to those of the corporation, you should consider advising the employee that they should retain independent counsel. But as I mentioned, you typically don't know if there's any adversity or even the potential for an adversity developing until you actually speak to the employee. So even if corporate counsel has reviewed documents that potentially incriminate the employee, without the employee having the opportunity to provide an explanation for what you're seeing, it's often difficult to determine definitively if there's adversity until after the initial interview. You might also get the question, can I talk to a lawyer before I talk to you? Once you get this question, plainly the most prudent road forward is to let the employee know that if they want to talk to a lawyer before speaking to you, or if they want their personal lawyer present during the interview, the company will give them a reasonable amount of time to make those arrangements. Now, whether or not the company pays for that lawyer is a different question, but in some circumstances, a company will pay for counsel on a limited basis just to determine whether the employee needs separate representation in order to move forward. You'll get the question, do I have a conflict with the company? Again, let the employee know that you will inform them if you believe a conflict arises since circumstances can change at any time. The employee should also be told to let in-house counsel know if they believe a conflict is going to arise. Do I have to speak with you is another question employees will ask. And the response here is that if the employee doesn't cooperate with you, there are likely to be consequences that can result in anything from disciplinary action to termination. Those consequences are typically set forth in the employee handbook, so you can refer the employee to that. If the employee still refuses to cooperate, one way to try to advance the ball would be to let them know that they can consult with their own attorney before continuing. And finally, employees will often ask, am I in trouble? Will my supervisor find out? Things of that nature. And you want to be clear that you're there to gather information in connection with the corporation's internal investigation, not to evaluate the employee's performance. That said, you're unlikely to be able to say definitively that a supervisor or a manager will not be told about what was discussed, so you're better off to not make any promises in that regard. Now, in addition to employees, during the course of an internal investigation, in-house counsel may also find themselves needing to reach out to interview a former employee. So the question then becomes, does the corporate privilege extend to the former employee? Well, the answer is sometimes. Most federal courts have extended the privilege to communications with former employees where those communications either concern information learned or actions taken during the former employee's previous employment, or the communications relate to privileged communications between the former employee and company counsel that occurred during the employment relationship. The rule of thumb here is that the attorney-client privilege will not protect conversations between the former employee and company counsel that go beyond the former employee's scope of knowledge during their employment. So corporate counsel should not be sharing any facts being developed during the investigation, and you certainly don't want to discuss statements obtained from other current or former employees with the former employee being interviewed. There are, however, certain state and federal courts that have not extended the attorney-client privilege to former employees. While this is not intended to be an exhaustive list, just by way of example, some of those jurisdictions include Washington State, the Eastern District of Michigan, and the Northern District of Illinois. In those jurisdictions, the former employee is treated like any other third party would be treated. So even when they are interviewed by corporate counsel, the corporation's privilege will not extend to that communication. To be safe, though, former employees should always be given an Upjohn warning to preserve the corporate privilege, even if there's a chance that it might not be recognized. As discussed, even if the communication with a former employee is not protected by the corporate attorney-client privilege, any interview notes or memoranda may well be protected by the work product doctrine. So again, when the interview is documented, counsel should be sure to incorporate their own impressions and opinions of the interview in order to increase the likelihood of work product protection as well. And finally, another category of interviewees a company counsel may well encounter during an internal investigation are functional equivalents of employees. These are generally agents or consultants for the company that are not actually employees, but are essentially functioning in that role, in the role of an employee. Some courts have begun to extend the corporation's privilege to communications with such individuals, but determining whether someone is a functional equivalent of an employee is typically a very fact-intensive inquiry. In 2020, a New York State court dealt with this issue in Frank versus Morgan's Hotel Group. The director of risk management's job was eliminated, but after he was let go, the company retained him as a consultant on a contract basis to do many of the same things he was doing as an employee. He was deposed as a non-party witness in a personal injury case involving one of the defendant's hotels. And during that deposition, counsel for the defendant instructed him not to answer with respect to his communications with defense counsel. In deciding that the former employee was, in fact, a functional equivalent of an employee, the court looked at whether he had responsibility for a key corporate job, whether he exercised independent decision-making authority within the company, whether he has a close and continuous working relationship with the corporation with respect to the matters at issue, and whether he had information that no one else was likely to possess. Now, of course, answering each one of these questions in the affirmative potentially opens a different can of worms with respect to the former employee's status as an independent contractor, which can implicate the employment laws. Nevertheless, best practice is to issue Upjohn warnings to any interviewee who might be considered the functional equivalent of one to preserve the corporation's privilege, if possible, as well as to make sure the consultant understands the parameters of the interview. And that is my last slide. Thank you for listening. And if you have any questions, please send them to us. And I will now turn things over to my esteemed colleagues from Indianapolis, who are going to
Thanks,
talk to you
Amiana.
about best practices.
Thanks, Amiana. Yeah, Alex and I want to talk to you today mostly about how to manage issues that arise during discovery. So, related to what Amiana was saying, sort of after or if in the event that these investigations or other matters turn into litigation. So, the first issue is legal holds, which for a long time people referred to as litigation holds. But of course, even with what Amiana is talking about, they're not required only when there's actually litigation. It includes pre-litigation, government investigations, tax audits, anytime that litigation is reasonably anticipated or reasonably foreseeable. Remember that it also includes when you start to reasonably contemplate initiating litigation. So again, certainly prior to litigation actually being filed. So, what needs to be included in a legal hold? You need to take reasonable and proportionate steps to preserve every element and every relevant and discoverable information in your possession, custody, or control. And I'll just emphasize the word control. It's the thing that we see most often missed in legal holds. It is information that is frequently is within the company's possession that is the focus of a legal hold, but it's important to remember, do you need to issue a legal hold to a contractor, an accountant, outside lawyers, medical providers, whoever else you might be using that's not in-house also needs to be included in a legal hold. So you want to focus on the custodians, identify the routine business operations that might be deleting information and make sure that those are stopped and identify sources and information or storage locations. Again, things that are frequently missed would be, I think, text messages, instant messages, thumb drives, iPads, cloud storage, voicemails, journals. And just remember again to not restrict this to just current employees, but also former employees are included in that. So what should be included in your legal hold? There's a variety of information that needs to be included in there. You want to make sure you've got definitions of what you're talking about, the categories of information you're referring to, certainly the instructions on how the preservation is to be undertaken. You should include the triggering event. Why is this information being held? The subjects of the data to be preserved, the time period, the time frame that the information needs to be collected back to, and how long it's going to be held. Certainly make sure that the employees understand the consequences of the failure to maintain the information and hold it. Also, confidentiality is an important one. Don't discuss, telling employees don't discuss or forward this communication without me on it or me present and checking with me prior to sharing the legal hold. It's important that they understand who can be contacted with questions. It's important to have an acknowledgement that they have read, understood, and are agreeing to comply with the notice. That's a significant protection for the company that the employee has indicated it understands exactly what this legal hold says and that it is going to comply. And then obviously you'd want to include any other jurisdictional or case-specific requirements. Again, make sure any features like an auto delete functionality have been turned off. And then it's really important that you periodically review the notice and follow up with the recipients so it stays fresh in their mind. Again, remember, particularly I think is useful when you're dealing with people who are outside the corporation itself. To make sure that they have continued to preserve the information or to let them know, for example, that it's no longer needed to be withheld or to be held. So when does it need to be released? Just do not hold it longer than necessary. One thing that we see happen often is that legal holds get sent out and they never get released. And then when another piece of litigation or investigation comes around, you have more information in your possession, custody, and control than you would otherwise perhaps wish to have in your possession. So you want to also ensure when you are releasing a litigation hold that there's not another hold that's ongoing that would also require preservation of that information. You see that a lot if there's, class action lawsuits or multiple lawsuits about a product. One case ends and another case is ongoing. That information needs to be held so that you have it for the other ongoing litigation. And again, make sure you notify recipients of the original hold notice that the hold has been terminated. Make sure you include IT, records management, anyone else who needs to have that information so that they can release it and that information can be properly destroyed. Alex?
Thanks, Megan. And now we're going to talk about document collection and retention. So you've done your investigation, you've issued your Upjohn notices, you've put your legal hold in place, and now you're getting some discovery. And we'll start with the scope of discovery. So what is it that you are allowed to discover? What is someone allowed to discover from you? And of course, these are some quotes from the rules. You'll see they're quite broad. Discovery is allowed for any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. That's the federal standard. You'll note that state standards are sometimes different. For example, talking more about whether things are reasonably calculated to lead to the discovery of admissible evidence, for example. And so you'll need to know what jurisdiction you're in. Importantly, though, the question of relevance, I think, is one that it causes many sticking points. So what is relevant to a case? Well, the courts interpreting this question have basically said that notice of relevance most often stems from a discovery request itself or from a party's complaint. Fair enough until you get down into practice. So, for example, if you receive a discovery request that says something like all documents that relate to the allegations contained in the complaint, what's relevant to that? Well, in some cases, that may be very straightforward, a slip and fall. So we want our emails and communications about the injury, the warnings we put up in place before the injury, etc. But in a securities fraud case, it might be a completely different story where you have two different competing sets of factual background and information. And the plaintiff contends that the investment in the company failed because of misrepresentations made in the disclosure materials or with respect to the failure of the company to carry out what the investment was supposed to be for, whereas the defendant thinks that the reason that everything fell apart has due to market factors unrelated to any of these allegations. And so there is a lot of tension in the rules concerning what is relevant and what is proportional to the needs of the case. So therefore, it's important to consider some best practices. How do we answer this question? And some of this might seem straightforward, but yet is the source of countless discovery disputes across the country. The first and most important thing to do is identify the custodians. Who has the relevant information? And again, important to note the word potentially relevant information. The standards for discovery do not require a determination to be made that the information is actually relevant to the case and will be used in the case. The information that is sought does not have to actually be admissible into evidence. It simply needs to be information that is potentially relevant to the claims. And typically, that question, answering what that is viewed in terms of the request itself. Is the request structured to obtain relevant information? If so, unless there's a demonstrable burden that attaches to trying to gather that information, even if it results in the production of inadmissible material or non-responsive documents, courts will typically allow it. We'll talk about the burden in a moment. Custodians, as Megan mentioned with respect to legal holds, custodians, it's also important to note, it means more than just you, meaning more than just the company or even the current employees of the company. Custodians may also include accountants, third parties who you've retained for some relevant issue relating to the case, things that the company has control over. And that's the law. That's the law in most jurisdictions, is that this obligation to produce responsive documents extends to all documents over which the party has control, not merely possession. In fact, going so far in a case from our Southern District here as to say that even if the documents were located in a foreign country, that alone would not bar or excuse a company from the obligation to provide them, search for them, and provide them. In addition to identifying custodians, it's important to identify relevant date ranges. So when did this issue take place? What were the time ranges relevant to the claim in the complaint? And then, of course, again, as Megan had mentioned, to identify relevant sources of data. So both devices and locations, physical locations, file cabinets, people's desks, etc., and devices, your email servers, your other document storage systems, phones, Teams messages. Where is the information relevant to the claim stored? And then finally, and most importantly, you need to determine search criteria. And again, this is case by case specific, of course. There is no one set of search criteria that would be appropriate, obviously. Generally speaking, courts to interpret this question have charged the party responding to discovery with conducting a, quote, careful and thorough search for responsive documents. And what that means, of course, again, is case specific, and it depends on whether that search is proportional to the needs of the case. But some guidance can be found in relevant decisions. For example, faulting and sanctioning a party for deciding to conduct only a cursory initial search, followed by rolling productions from a more thorough search, as opposed to starting at the beginning and doing everything that needed to be done to find the relevant information. So the takeaway here under the best practices is obviously there are many issues where we can object and issues we can raise, but the purpose of discovery is to make trial less of a guessing game and more of a fair exchange of information between the parties. And so if you have to choose a side upon which to err, either being producing more or producing less, you're going to be better off generally by producing more. That said, there are plenty of objections that can be raised to discovery. This is, again, the source of much litigation, despite judges not wanting to hear it, typically. And typically, if you are going to object to producing some documents, an objection will only be considered valid if it specifically informs the other party and the court about the nature of what documents you are not producing, and then why you're not producing them because of a particularly burdensome impact that that search has on you. And so one way to target and to refine and defend any objection is to make it be based upon your search parameters. So the things we just went over, the custodians, the time frame, the search criteria. If you can tie your objection to not producing documents to a set of search criteria and search parameters that you've put in place, and you can explain why those are the criteria you use and why those are reasonable and proportionate to the case, that's going to be the best way to defend an objection to producing documents to the extent that gets raised with the court. Certainly, it goes without saying that selectively producing documents that are deemed helpful to your position and not producing those that aren't isn't going to cut it. And Megan and I have seen this in practice many times, in one particularly notable experience where another party did just that, and in fact went a step further and actually created some emails talking about how that's what they were doing and then produced those to us as well. A very risky strategy, one we would not recommend, ended up resulting in a significant sanctions award against that council. So we can all understand and appreciate against that party, excuse me. We can all understand and appreciate the frustrations imposed by Discovery, but would not recommend doing that. One other thing to consider is the idea of metadata or ESI, electronically stored information. So in most federal jurisdictions, the parties are asked in the case management process to identify and explain what they intend to do with the production of this information. And so something to consider in the outset of any discovery request is that same question. And so metadata is essentially data about data. So table and row column headers in a spreadsheet, information about when an email was created or modified or a document, etc. It can be very difficult and expensive to search for and produce this information. This is not just simply searching for keywords or documents from a certain party. And so a question to ask is, do you need this for your case at the outset? Is this something that would be relevant to know, for example, when a document was modified or created or emailed to someone? And that's something to consider up front, because if you don't need it and you can cut it out, you will certainly be able to save some time and money. And finally, in this context, I'm going to talk briefly about the duty to supplement your responses and retain information. And so the duty to supplement is not perhaps what you might think on first blush. A party has a duty to supplement a response in a timely manner if it learns the response is incomplete or incorrect and correct information has not been provided. Otherwise, you don't. It's distinct from an ongoing requirement to continue producing documents. Typically, that only will come up if there's a request. And then as Megan talked about the litigation hold and the preservation of document issue, that's important to consider during the case as well. So again, a relevant experience that we've had to this, there was a case where a party had failed to disable standard practice of deleting employee email after a certain period of time after they had left the company. And that became known during the case and resulted in a spoliation issue that, again, was not favorable for that party. So be sure to continue investigating that issue as the case progresses. And now we've reached the CLE code word issue. So let me just note that, as I mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code words. So all Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the word privilege into the Q&A section of your screen. Please make sure to hit the send button so that it registers. And in case you missed it the first time, the code word is privilege. And now I'll pass back to Megan to talk about counsel's role in discovery.
Thanks, Alex. I think attorneys often view their role in the discovery process itself as being incredibly limited. Discovery requests are sent to clients, and then the in-house counsel will send the discovery request perhaps to relevant custodians, and then send a litigation hold or a legal hold, and then sort of sit back and wait while the client or the custodian gathers the relevant documents. But the law really requires a significantly more active role and a more critical eye to what the custodians or your clients are actually doing and what they're gathering. So it's important to understand that counsel has an independent duty to monitor and supervise or participate in efforts to comply with the duty to preserve. And that's with respect to legal holds. So just as you can't sit back and let somebody else issue one, you have an ongoing obligation to monitor those legal holds, make sure that they're being complied with. The same is true for the discovery process itself. So we obviously have rules that govern the way that we as lawyers behave, and so the rules of professional conduct set forth that we can't obstruct as lawyers and other parties access to evidence. We have to make sure it's our job that evidence is preserved and that it is produced if it is responsive to the request. The Seventh Circuit has similar standards of professional conduct, and I think all of the circuits have similar ones. Again, really the goal is, as Alex said earlier, the goal is not to find a way to withhold information or hide it. I think attorneys and parties often want to disclose as little as possible, thinking that that is the safest route, but it's really directly contrary to our duties and the purpose of discovery. As the Seventh Circuit says in Rule 24, we respond to document requests reasonably and not strain to interpret the request in an artificially restrictive manner to avoid disclosure of relevant and non-privileged documents. And Rule 27, we won't object solely for the purpose of withholding or delaying the disclosure of relevant information. As Alex said, we see this happening all the time. And it's really, again, contrary to your obligations as a lawyer, and will open you up to sanctions. I think this is relevant to what Alex was saying earlier. There's many cases that say this, but although concealment and gamemanship were once accepted as part and parcel of the adversarial process, we have unanimously declared that such tactics no longer have any place in our system of justice. And as I said, it will lead you to being faced with potential sanctions. And the scope of sanctions is broad, right? It can be attorneys paying attorneys' fees or costs, and more severely, adverse inferences with respect to claims or nullification of potential defenses, or ultimately dismissal and default. Red Spot is a case from our Southern District that was pretty significant on these issues, said that the law does not protect those who decide for themselves that they are right and withhold evidence on that basis. Another case from our Northern District said counsel has a duty to ensure that their client completed a thorough search of its records in responding to opposing parties' discovery requests and to monitor its production efforts. So the question is really, so what then do you have to do to make sure that you are meeting your obligation as an attorney when custodians are gathering documents, or your clients gathering documents and producing them to you? How much sort of second eyes do we actually have to lay on these documents that are being produced? And there's several steps. I mean, the first step is make sure that you have thoroughly reviewed the discovery requests that have been provided to you. If you're relying on outside counsel, make sure that you as in-house counsel have reviewed them yourself and that you understand what's being asked for. Identify the individuals that have the discoverable information, implement the appropriate legal hold, and then discuss in detail the items that need to be produced. But then you have to review the information that's collected and question the completeness of that and identify any areas that are incomplete. And those last few points are really the ones that we see most often skipped. And it's not usually, like I said, it's not usually because of ill intent, but it's because of money or time constraints. Someone else has already reviewed these documents. You gave very specific instructions about what you wanted to be produced to you, and so that you can provide it to outside counsel, and you don't have time, frankly, to look through them again, or you don't want to pay your outside counsel to review them again. And so we just rely on those custodians. But the problem with that is that you really miss a lot of potentially important information. So let me go back one second. When you're outsourcing your discovery to a custodian or to a client, they often just do not collect everything that's responsive. They withhold items that they think are privileged or confidential. They don't understand very often how narrow the scope of the privilege is. Like Amiana said, it often doesn't apply to people who think it does, or it doesn't apply to facts and they think it does. So they've decided for themselves that they're going to not send you communications that they had with counsel, or they withhold it because they think it's going to harm them or it's going to harm the company and no one will know. And so it's really your duty to make sure that there aren't things that are clearly missing. Similarly, we hear a lot now, hey, can you guys use AI? We want our outside counsel to utilize AI as much as possible to keep the cost down. Well, courts repeatedly have said, we are not okay with you outsourcing your discovery obligations to your clients or custodians that you've given the discovery request to. I'm not aware of any case that's gotten to this point yet, but I'm confident that they are going to say we're not comfortable with you outsourcing it to AI either. And we have plenty of cases about using AI for legal briefs and the court's frustrations associated with that. And so it's really just important that, again, you're reviewing what's being produced. And I think the thing that, like, we've noticed many times that AI, for example, couldn't catch when you're trying to do a second review or your own review to make sure that you have everything is that there are sometimes, obviously, like I said, things that should be included that are missing. If you know that a certain department always issues a status report or files certain reports, and those aren't in there, that's an easy follow-up for you to say, okay, I've just kind of done a quick checklist of what I know this issue is, what I expect to be in here. Let me do a quick search, make sure we have those. If not, you can go back and get those. Review of those documents by you may also identify, which we've seen many times, a new legal issue that or a new defense that you could raise, or a significant weakness in your case. Or just other concerns that you hadn't thought of. Alex and I had a case where a client was did a great search for responsive documents, but it pulled up instant messages between employees. So employees who were just purely speculating back and forth in what I think they thought was a very informal conversation about what was going on at the company. It had to be produced. But it was an opportunity for us to say to our client, hey, you guys are retaining, I don't know if you're aware, you're retaining instant messages that your clients are sending each other. And there was no deadline, like there was no period at which those got deleted. So, of course, outside of a legal hold, they immediately took steps to no longer retain those. And we also checked our own internal policy about retaining instant messages, because those are the exact sort of things you don't want to be having to produce in discovery. The people don't have to explain why somebody at your company said X, Y, or Z. Again, clients often or custodians aren't reviewing for privilege. They don't understand it. Another one we've seen that you can do really quickly as a search to just check what you're being provided is to search for things like things that you would know would be confidential or trade secrets. If it's there's design drawings, for example, they have, a logo or corner sort of legend that indicates that there's a design and it's been updated. And so you can do a quick search of those documents and say, okay, let me make sure that we have covered that. And then if any of those are in the production, should they be in the production? Should they be taken out of the production? Do they need to be marked as confidential or attorney's eyes only? Again, you can run attorneys' names, your own name as in-house counsel, and make sure that those, do they need to be pulled out? Do they need to be produced but put on a privilege log? You just want to make sure you're really putting a second set of eyes, catching any issues of things that are missed or things that need to be corrected. Again, another one is failing to gather personal emails or phones and making sure you have those. And then I just want to mention one other issue with respect to the role of counsel that we see a lot, and it's a failure to understand what your rights are, particularly if you're involved in discovery because you've received a subpoena. You might be entitled to attorney's fees and costs. That's very common for reasonable expenses associated with having to gather and search for and produce documents. You may need to issue or file a motion to quash or seek a protective order for the documents that are being asked for. And a thing that we see really commonly is the creation of documents. You are not required in a document request to, and you should not be creating any documents. So sometimes people will create another document, gathering in one spot sort of all the information they think somebody wants. Definitely should not be doing that. So it's important to consult your outside counsel if you have any concerns about a subpoena that you receive as well. All right, back to Alex.
Thanks. Yeah, and one other point to add on that is, as an in-house counsel, I think a red flag that Megan has highlighted is if you are receiving a set of document requests and essentially being told to have at it with no instruction, that ought to be a red flag for you, right? In other words, that you're going to need to have a more detailed and thorough discussion with your outside counsel and internally as well about what should you be doing to respond to these, as opposed to, let me just hand these to the person who did this and have them find the right documents or have them answer the questions as presented. That can lead down a bad path. And I think so Megan's highlighted that not only are there rules that would suggest not doing that, there are court cases that suggest not doing that, but it might put you in a bad situation where you have a discovery fight that you could have avoided. And to that end, so we'll talk now a little bit about how to reduce and manage costs associated with discovery. And there are a variety of approaches here. Obviously, discovery is very expensive, time consuming. And all the approaches I'm going to talk about now could be used in combination with one another, and I would recommend that. And the first, and I think really the best overall approach is trying to reach agreement with the other side about what it is you're going to do and what it is you're not going to do. And what I mean is, going back to that example we talked about before, a request, a very broad request, all documents that relate to the complaint, or all documents that relate to the investment or the prospectus, or whatever the case may be, a generic broad request. Well, what does it mean? Well, one way to do it is have your own answer to that question and never tell anyone and just produce what you think you should produce and withhold what you think you should withhold, and then possibly have a big fight over that. Another approach, and it involves some upfront cost and it involves showing a bit of your cards, is to go to the other side and say, this is what we think that means. Here are the people who were involved in that issue. Here are the terms that we think are relevant to your claims in this case, or our defenses in this case, or what was said in the offering materials and so on. And maybe even here's a list of the search terms we plan to run and the timeline and the custodians and the sources of materials and devices where we're going to look. And I would say that 9 times out of 10, that approach is the better approach than just simply doing it yourself and seeing, and do it and see where the cards fall and have that fight later. Not always, and obviously you can't always reach an agreement. I mean, one aspect of this is that you try this and the other side says, no, I want 10,000 more search terms, I want way more custodians. Or what I've seen often is, I don't know what you have, so I'm not willing to limit what I'm going to agree that you do to what you say. I want you to just give me everything. And of course, the frustration with that is, well, this is what I think everything is. So obviously there is some pushback, back and forth here about what to do, and you have to be willing to show your cards a little bit, and you're also going to have to be willing, if you're asking the other side to agree that this is what we're going to do, you would have to be willing to agree to something similar from them, right? Now, I mean, there are different scenarios in every case, and perhaps only one party has most of the relevant material, fair enough. But if you're asking for a certain time range, you're probably going to have to be willing to accept that as well. So think about that. If you are able to reach an agreement, you then can avoid major headaches, discovery fights over the scope of your searches, which custodians should have been searched for or not, maybe even what's considered to be within the privilege, and whether you have to review it or whether you can just simply withhold all those documents, and so on. And that does tend to be the best way to minimize costs and expense with discovery that we have found. There are, of course, other approaches that, the traditional approaches have a law firm, doing a review themselves, your outside counsel, this is kind of what has been the case for many, many years, of course, usually very expensive, often staffed by associates, but there are lots of tools available now. I'll talk about a few more of those in a couple more slides, but there are tools to help make that review more efficient and effective. You can tag documents, you can highlight key terms, you can group them by theme, by custodian, by issue. You can, assign different batches to different people. You can use all of those tools to try to make the review both more efficient and also to make the review more effective. Because while this is typically, I would say, the most expensive approach, it can be very helpful if the lawyers from the outside firm actually put eyes on the key documents that they will then be using later in deposition, summary judgment, or a trial, to have learned that at the outset, as opposed to using an AI review or an external review, and those documents don't pass by those lawyers until much later, where maybe they could have benefited from seeing them sooner. I will emphasize, though, that to the extent as an in-house counsel you're managing this kind of a review, it is important to try to get every bit of your power to try to make sure the review is actually a review, meaning you're not just clicking buttons to mark things as responsive and not responsive or privileged. Someone's reading them. Someone's actually making sense of the material, so we don't miss privilege issues. We don't miss important, concerns nobody knew about. We don't miss the disclosure of confidential information. Certainly also in this context, you can rely on some AI tools, which I'll get to in just a second, to help make it even more efficient. Of course, another approach is what I was just mentioning, either offshore or outside, contract attorneys to do review. Many companies use these. We've been managed those projects both externally and outside the United States and inside. Certainly cost savings there. Certainly also sometimes a lot of bodies to throw at an issue, which can be very helpful if you have a time constraint. Offshore review, be careful about language barrier. And in either case, you have to be careful about quality control, because when someone is doing this more as a sort of a staff level, employee level, as opposed to actually being involved in the case, they may not appreciate the nuances of the case or be able to suss out an important issue. They're really just following direction. And my experience managing those kind of teams of reviewers in our firm in a piece of litigation, they can often be a bit overwhelming, the sheer number of questions that come to you because you're not reading the documents, and these people are. And so there can be more cost there than you might anticipate, and also some risk of things being missed. And finally, let me talk about other tools that can be used in any of those contexts to review technology assisted review. So this is AI type review, and there's really kind of two approaches. One is typically just referred to as technology assisted review. The other is really generative AI. So talk about technology assisted review first. This is typically what is the most common approach to reviewing documents. It's really using algorithms to find similar documents. And the key is that what you're doing is you're taking typically an attorney or perhaps someone else who has a lot of knowledge about the issue. You're having them go through some test batches and tag them based on the tags you've created: responsive, not responsive, privileged, hot documents, whatever the case may be. You create those test batches, and then the AI will then apply those test batches and that review structure by the actual human who did it to all the documents in the document review set, and then can typically give you percentage-based review of the remaining documents. For example, this set of documents we think is 80% likely to be responsive, and this is 70 and 60 and 50 and so on. The value there, of course, is you can either make an internal decision to say we're not reviewing anything below a certain percentage, or you could have an agreement with the other side that says we're not reviewing anything below a certain percentage. And then you could also take a further step and say, we're just going to produce it. If it's marked this way, we think it's responsive, here you go. Obviously, some risk there, you haven't seen it, etc. But that is still a good way to save some time and some money. Obviously, not everyone's familiar with this process, so there's some risk that it just gets rejected because it's too newfangled. Generative AI is like that, and this is really new, at least in the last few years. But this is removing the human component and simply asking the AI to do the work. So give me the documents that are responsive based on my input, my criteria. And you might think of it as sort of garbage in, garbage out. The better instructions you give the AI, the more likely you are to get what you want. Obviously, there are some pretty significant risks here. This is new technology, and Megan talked about this. I mean, there's the potential that it doesn't appreciate either just the nuance of language, doesn't know how to exercise judgment, or really just hallucinates. We've seen it already with briefs where AI is basically inventing cases to support a position. The same risk exists with a document review, that it's telling you something about the documents that's not true because of the criteria you gave it. You also have a privacy concern. Any kind of AI review needs to be closed. In other words, you're not putting something into ChatGPT or whatever the case may be, because then you have the risk of disclosing confidential information to a public AI forum that puts it out there, could expose confidential information or privileged materials. So in the end, if you use this kind of review, you still need a human element, either a QC process, review batches, search for hot documents or terms, something to make sure that human judgment is applied to what's done. I think we are just out of time, so I'll turn it back over to Megan.
Yeah, thank you again for participating in the first hour of today's CLE workshop or webinar. I am going to turn it over to Ronald Levitt, a shareholder in the Denton's tax practice. Thank you.
Okay, well, welcome. Did I mess that up? Sorry about that. Hello, my name is Ronald Levitt, and on behalf of my law partners, Michelle Levin and Greg Rhodes, we are happy to welcome you virtually to our offices in the center of the universe. That's Birmingham, Alabama. Actually, Greg and I are speaking here from Birmingham, in our offices. Michelle is joining us from about 4,000 miles away. She's traveling to jolly old England and is in London. And so she's going to join us, and this shows how great technology can be.
We'll see.
Yeah. She thought she was getting away for vacation, but she just couldn't get away. So, but regardless of where we are, our goal today is to speak to this Denton-sponsored gathering about, I guess we can move this forward. There we go. About serious and impactful changes that we're seeing in the tax world. I've been practicing law for over 40 years. I've never seen a year like 2025. And there's so many things that are impacting us on a day-to-day basis. You know, we got a bunch of calls today. I know, Greg, you had it too. Michelle, you might have avoided it a little bit, but all the different people in the IRS that are calling us, letting us know they're on furlough. And so we've got all these things that we have to deal with on a day-to-day basis that are impactful, and that we hope our discussions will help the people who are listening to us today get your head around these changes that we're expecting on a daily basis and how you might prepare for that. To give you a little context, the three of us lead our tax controversy practice in our Birmingham and Huntsville, Alabama offices. Michelle's based in Huntsville, and coordinate with other Denton's offices in the Denton's world all over. I wanted to tell you a little bit about ourselves, not a lot because you can look it up, but I'll give you a little context of what we do. Our first speaker, after I give this introduction, is going to be Michelle Levin, who will speak about IRS operational changes. She's a Birmingham native, graduated from the University of Texas Law School, and she worked in the law firm world, most notably at McKee Nelson, and eventually went to work for the dark side, worked for the DOJ and the U.S. Attorney's Office, and joined our firm in 2013. And she is incredibly creative and a real asset for all of us. Greg, who will end our program today, will speak about strategic planning for legal teams. And he heads our practice group. He earned his law degree from the University of Mississippi School of Law and got his LLM in taxation at NYU, where I met him, recruiting him. He joined our firm in 2008 and has helped grow our practice group to a total of about 12 lawyers now. So
that's right.
So, you know, having in a little town like Birmingham, having 12 folks that do tax controversy on a daily basis is a little bit unusual. I'm the old man of the group. I've practiced law for over 40 years, but my practice is a little bit different than others. I went to Alabama and got a law degree and an MBA, and I went to Florida for my tax degree. And the first 20 years or so of my practice was mostly transactional kind of work, estate planning, representing closely held businesses, with a piece of it being controversy. And then about 20 years ago, started developing a practice in an area that relates to conservation easements. And that turned into, I ended up joining, it was then Cerroti and Permits, now Denton Cerroti, in 2005, a few years before we recruited Greg, and a few years before Michelle joined us. And since then, we've grown into a group that does tax controversy in all different areas. But my perspective is, having been a transactional lawyer, I looked at that as the lens that I look through things. And I think that's a little bit different than Greg, although you've done some transactional work, and Michelle, who's always been a controversy person. And so those lawyers who are here, you got to have to look at the lens that you're looking at. And so what a transactional lawyer might look at, I've learned a ton by working on the tax controversy side, so we can see what does it matter of how you do something. I led a panel with the ABA tax section a couple of years ago where we had a couple of the tax court judges on the panel, kind of teaching the tax lawyers who were there what they look at and how you gather evidence and how do you deal with those rules that we transactional lawyers didn't have anything to do with. So that we bring, I bring a little bit different viewpoint. And so, but Michelle and Greg kind of lead our trial teams. And so what we wanted to do today is we're going to focus an awful lot on the litigation aspects, but in the middle, I'm going to talk a little bit about what I think is a really important thing that we all have to be worried about, is the One Big Beautiful Bill Act that was signed into law in July, and what it means to tax planning. And as tax lawyers, we need to be aware of all of that. So with that background, Michelle, why don't you start talking about the IRS operational changes?
And Michelle, before you begin, I just wanted to make sure everybody knew that speaking of technology, I'm not actually a ghost or a hologram. I think I'm appearing and disappearing from the picture, but we are actually here.
I am too. That's good.
So with that said, hopefully your London connection's a little better.
Thanks, Greg. Yeah, it's better over here. OG electricity, and probably should eat a little more, help you stay in the picture better. Thanks everyone for attending today. I know that we have a large audience, and I'm sure everyone is sitting in the audience thinking, why do I care? about IRS operational challenges. I'm not a tax lawyer. I'm not a tax person. And the reason why all of us care is because everyone has to file a tax return. Probably you file your individual returns, and the companies that you work for are going to be filing multiple returns. They might be filing more than one corporate return, partnership return, and also employment tax returns. So there's always a lot of tax returns that have to be filed. The IRS itself processes approximately 266 million tax returns every year. And in addition to processing all the tax returns, the IRS is also responsible for issuing guidance to everyone about how the changes in the tax law impact how you prepare your return, how you report items on your return. So you're going to hear a little bit from Ronald about the new legislative changes, but part of what the IRS is supposed to be doing is issuing guidance to all of us as taxpayers and all of our businesses as taxpayers about how the tax law affects what they're reporting on their return. Guidance comes in different forms. You can have formal guidance. It could be as complex and sophisticated as formal guidance in the form of regulations, or it can be as simple as instructions for a form. But every time there's a change in the tax law, every time there's a change needed for an IRS tax form, those instructions to the forms have to be changed, and there has to be people at the IRS to do that. And so, as Ronald mentioned at the outset, a lot of those people have been on furlough, but even before then, the IRS has been losing a lot of its personnel. So I'm going to talk a little bit about that, and I just wanted to set the table for why it's going to be important for everyone attending this webinar, because the changes at the IRS are going to impact how your returns are being processed, how guidance is being issued, and how issues that you run into as a taxpayer are going to be resolved through the IRS. So I'm going to talk a little bit about who's running the IRS at the moment. So what happened is, once the Trump administration took office, I'm sure all of us remember, it was not too long ago, but they really started a process whereby they sought to reduce the size of the federal government. So they looked at various different paths that they could use to shrink various federal agencies. And when it came to the IRS, the administration implemented multiple programs to reduce the size of the IRS. There was a deferred resignation program that was kind of offered across all federal employees, where you could retire as of September 30th. So the IRS lost a lot of people to that. There was a separate program for Treasury that was a deferred resignation program. There was a voluntary separation incentives for people at the IRS, including early retirement. And then there was also involuntary separation. And so what ended up happening is that we saw a lot of the folks in leadership positions leave the IRS, either through deferred resignation, early retirement. And so now we have some pretty substantial vacant spots at the IRS, spots that are either vacant currently or being held by acting individuals, which means they don't have the same level of authority as someone that's permanently in that position. So the most important, acting IRS official at the moment is the commissioner, who you may or may not know is actually our Treasury Secretary, Scott Bessent. So we know that running the IRS is not his full-time job, and having our Treasury Secretary in the same role as the commissioner limits, his availability to run the IRS. Some other significant acting roles that are going to impact taxpayers broadly is the acting chief of the Office of Independent Appeals. So appeals is where, 90% of tax disputes get resolved. It's the IRS administrative resolution process. 90% of the disputes get resolved there, and they're right now being headed by an acting chief. Which of course, limits appeals' ability to formulate and develop new policies that it would under a permanent chief. Likewise, we have an acting chief counsel, that's the head lawyer for the IRS, Kenneth Keys. And again, he also is, moonlighting at the IRS. He's a permanent employee over at Treasury. So without a chief counsel, the chief counsel issues regulations, issues guidance, leads the litigation objectives and priorities of the IRS. So having someone acting in that role, kind of limits the effectiveness of the chief counsel's office. I also wanted to point out that the large business LB&I division is currently vacant. The commissioner chair is currently vacant. So again, there's no one really leading the policy in that division of the IRS, and a lot of large business international clients. Denton's has a lot of clients that fall into that category. And then also I wanted to point out that the online services is vacant. And again, I personally think that's critical because what we're seeing is a lot of transition of IRS services into the online space. And so when you have vacancies at kind of these top posts, what happens is that it limits their effectiveness. I'm not speaking to anyone individually's effectiveness. I think everyone is really working very hard to run our government effectively and efficiently, but it does create problems if you want to have sweeping policy, not necessarily policy changes, but really just someone to steer the ship, to be kind of the commander and lead the policy, lead the objectives for those divisions. And right now, a lot of these spots are vacant. And so if we could just go, I'm going to go to the next slide to show you guys a little bit about kind of the limited experience so this was a slide, this was a chart that was in Bloomberg Tax. And basically what it was showing is that a lot of the folks that are holding these high positions at the IRS have very few years of experience at the IRS, some more than others. And it's always positive to have new people and fresh ideas. So I don't want to say that that's going to be problematic, but the issue is that a lot of these folks don't have the institutional knowledge or experience, having been on the government side and the private sector side. There's a lot of procedures in place, and while it's positive to try and maybe figure out ways to streamline those procedures, when you're changing things and when you have someone new in charge, it makes it a lot harder to get things done because all the people at the bottom are used to following those procedures. The people at the top don't know them as well. And so that's just kind of something that we've seen where there's a lot less certainty, a lot more unpredictability because the people that are filling these roles don't have the long-term experience. And an issue that we're running into also is just actually finding the right person to talk to at the IRS, because we have a lot of folks that are we have a lot of roles even above and beyond the org chart I show you that are just vacant right now. And so there's really no one in charge of making certain policy decisions or certain practical decisions to address kind of wide-ranging problems.
And Michelle, in addition to just kind of the lack of experience you have there, I mean, how many commissioners have we had in the last year? I think 7, and now a new CEO. So, there's a lot of change going on, and I think a lot of no direction funneling down that we're seeing. So it's really a period of a lot of flux right now.
Yeah.
Let me add, Michelle, I'm sorry to interrupt, but you're talking about the higher level, the people that are in DC or in the in national kind of leadership positions. I know my experience in dealing with people at IRS appeals and even dealing with counsel, there's been so many of those folks who have been around, they're pretty long in the tooth and they've been there for decades, and they just have gotten fed up themselves and have left. So the service not only has a problem at the head of it, but they've got a problem with the body of the worker folks who handle that we deal with day in and day out on audits and on cases. And I think that's a real problem because those years of experience often led to being in a position for us to be in a position to actually be able to work things through with them because they had a better understanding of the big picture. Whereas somebody just out of school or have not been working for the government comes in, they don't really have, all they're going to do is what they're told, and they don't have that experience. And I think that's something to keep in mind when you're trying to deal with these kinds of issues.
Yes, and just kind of that's exactly what we're going to talk about a little more is just the workforce drain and how many employees have been separated from the IRS. And just to Greg's point about losing some of the, just to follow up on what Greg said, when you have a large disruption at a high level, it would be the same as any business, right? To, lose a lot of the top employees all at once, it results in a lot of uncertainty, and it results in a lot of disruption. Whether it's long term, it could be positive or negative, yet to be seen. But certainly in the current term, it is very disruptive. So as Ronald was saying, we're actually seeing, we've seen people leave across the IRS. They've lost 25,000 employees altogether. That's 25% of the workforce. Most of them were through voluntary separations, but again, there were some that were fired. I also wanted to point out that there was a loss of 3,000 probationary employees, which were actually, when you hear for the term probationary, you think it's someone brand new, and they were brand new to the IRS, but a lot of those folks were actually quite experienced, and we had been working with several probationary employees when they were separated from the IRS. And so that was a big loss for the taxpayers to have people with that quality background and experience. I think some of them were I had an appeals officer that was a former in-house counsel for General Motors, very, very sophisticated individual, because again, right before the change of administration, the IRS had done a bunch of hiring. So they brought in a bunch of people, but they'd also, in some situations, had made a concerted effort to bring in really high level people. So the loss of probationary employees was, in some cases, very detrimental for taxpayers and the IRS. And then I'm going to show, this is a chart that we're lucky that the Treasury Inspector General has collected all this data for us and put together all these charts so we can kind of see where the losses are. They're nationwide, right? So they're happening all over the country. They're in all different divisions. So as you can see on the right-hand side, we've lost 27% of tax examiners, and those are people that are just processing returns. And so in some cases, when you have to, for example, file an amended paper return, which is what a lot of people had to do when they were claiming the ERC, the Employee Retention Credit. Those all had to be filed in paper, or any time that you have to amend your payroll tax reform. And so then that has to be payroll tax return. That has to be keyed in by a tax examiner because it's in paper. They can scan some of it, but then you have to have an examiner review it. And we've come across multiple situations where return is misstroked. They're miskeyed in by the IRS official or examiner. And so then you have to go through a very complicated process to kind of get that resolved. And that can be, problematic when you don't have people working at the IRS that can answer the phones, that can help you resolve these kinds of issues. And so there's lots of different avenues to pursue, but that's been one of the places where we've seen revenue agents. Those are the individuals in charge with actually auditing returns. And so we've seen a 26% drop in revenue agents. And at the outset, what we saw was just a lot of audits being closed, especially the high net worth individual audits being closed with no change. But now we're seeing audits start to open up again. Now they're a little bit lower level, not as complex, but we are seeing an influx of audits come in. This is just a chart again that shows kind of the businesses units that are affected. So small business, self-employed, they're responsible for the small businesses. They also are responsible for issuing a lot of the guidance. Large business international is going to impact a lot of businesses. And then taxpayer services impacts everyone because everyone has to interact with taxpayer services to get their issues resolved with the IRS. So I just want to take just a couple minutes because I'm going a little bit over my time to just talk about one other, major aspect of the operational changes. We're seeing the audits are smaller in number, but scarier in undertaking because, you might have someone that's not as well trained. We're also seeing a lot of automated audits, which is very, very difficult because you can't ever get a human being involved. And so you're getting a letter, you're responding, no one's reading it. And so it's a very difficult process. The Taxpayer Advocate Service, which used to be a tremendous resource for folks that were having issues with their audits, is completely overwhelmed. And as of right now, it's shut down for the government shutdown. So it's really, I've never seen in my life so many instances where we've had to get congressional representatives involved to try and resolve IRS issues, but that's a lever that we've been pulling more now than ever, just because of their limited number of individuals in the IRS to contact. Now, the last kind of impact of this changes is that the regulations are in flux. The administration's pulled back a lot of the regulations. That's been somewhat beneficial because a lot of regs were being proposed right at the end of the last administration. They were overly complex. There was corporate spinoff regulations. These were having to do with tax-free spinoffs, and they were overly complex. A lot of the commenters took issue with them. We also saw complex regulations with the corporate alternative minimum tax that have been pulled back. There were regulations involving stock buybacks and when you would have that funding 1% tax that were not really consistent. When I don't want to get into detail on all of these, but it had to do with, funds that were treated as being contributed to foreign entities that are buying back stock that weren't actually stock buyback transactions. But in any event, the larger picture is that a lot of these regulations have been pulled back, which is positive to the extent that the regulations were overly complicated. They weren't really consistent with reality. It appears as though Treasury is being really responsive to the comments that they're receiving from the public. The downside, of course, is that without regulations, in a lot of cases, there's even more uncertainty because you don't know how the IRS is going to treat certain things under the law. Tax preparers don't really know how to report certain items. But the long and short of this slide is to kind of let you know that if there are any tax regulations that are either proposed or in temporary status that are going to affect your business, now is a really good time to comment because Treasury is really heeding those comments. So with that, I will turn it over to Ronald to talk about all the legislative changes that are going to require regulations so that you can be ready to comment on them and the IRS will hear your concerns.
Before you go ahead, Greg.
Yeah, I just wanted to make a comment because it's a theme that runs through here. You think you want less IRS, you think naturally people hate regulations, you want less regulations, but there's a flip side to that. Regulations also can add certainty. And so we're really at a stage right now where the regulations, for some reasons that we don't have time to get into, are under attack in the courts for the people that are challenging the regulations that are problematic. And so you have probably a little bit of an IRS reluctance to move forward with regulations if they're going to be under attack anyway. But then you also have this dynamic where you don't have the people in the IRS that can really deal with the regulations and drafting them and getting them through, taking comments. So you may think, well, this is going to be a great world where there's just no regulations, but you really got to think of the flip side of that is when we get in the audits, there's a flip side to not having an IRS on, it can be helpful with audits, but it can also be harmful when you're trying to get things resolved. So
yeah, I was going to kind of go in the same direction as Michelle and Greg kind of birthed an attack that has had some regulations been invalidated and created a path under the APA. And I probably don't have enough time to really talk about that, but that's something that if you do want to attack a regulation, there are paths to do that. But as Greg said, you may get what you wish for, which is a rule that you don't know what the rule is. And
yeah, well, yeah, right. And the regulations also a lot of times provide safe harbors. So there's always a benefit to those. And one area that I know taxpayers have really been seeking regulations in is the economic substance. Now that the IRS has revived that statute, they hadn't really been using it for a while, but now it's back in play. And so there's been a lot of requests for basically an angel list. What are some tax motivated transactions that aren't going to be subject to the economic substance challenge? And the IRS has not issued those regulations yet. So there are some circumstances where you really want regulations and not having them can be a real drawback. So yeah, it seems good in the short run, but in the long run, depending on your situation, you might want those regulations. And I bet when we hear all these changes, we're going to say we want a little more guidance on on what they mean and how we should report them and all those good things.
okay, well, and just to follow up and then transition into the new legislation, what we've experienced in some of the areas of the law is when there's not a lot of guidance out there. Then sometimes the government will say, I just as soon figure out what the guidance is by going through the courts and have court decisions decide what that is. And that's not always a happy place to be because you don't have any control over it. The courts may or may not come up with a logical approach that you can live with. And so that you're right, Michelle. We're going to see a lot of changes with new tax law. It's really you got to hand it to the president and his marketing ability. Who would have ever thought we'd have an act called the One Big Beautiful Bill Act? But that's what we have. That was signed into law on July 4th. It is really the other shoe to what was in his first administration years ago, the Tax Cuts and Jobs Act of 2017, the TCJA 2017. And what that was a provision that came out of the reconciliation process that Congress went through. If y'all remember back then, you didn't have total control of Congress, and you had razor thin control. And the only way you could get this through was through the reconciliation process, which had the Byrd Amendment that meant you really had to count dollars and pennies and toes to figure out what would be the impact of these things. But what went into the TCJA was a very pro-business approach in Congress that birthed some provisions that because of the reconciliation process of the Byrd Amendment, these had to be phased out or sunsetted. And a lot of those provisions sunsetted in 2025. It's clear that both the TCJA and the One Big Beautiful Bill Act are pro-business tax bills that arose from policy changes within our government. we've been living in this kind of yo-yo land in between the Republicans and the Democrats about how tax policy is going to work. And so now we're in the yang of the yin that we had in the Biden administration. These law changes are what they really are doing. And what I think is pretty interesting about it is that they're making business owners rethink or at least reconsider choice of entity decisions that have really been in place since the Tax Reform Act of 1986. And that's when the corporate and individual rates inverted. And that's when you got rid of the general utilities doctrine, which really eliminated it for flow-through entities, the double tax. And so since 1986, the knee-jerk reaction, especially for most closely held businesses, had to be a flow-through entity, whether they be S corporations or partnerships or sole proprietorships, and a much smaller use of C corporations. When I first started practicing law, most closely held businesses operated as C corporations, and that flipped completely. So when we're thinking and studying the changes in the OBBBA, or One Big Beautiful Bill Act, the real driver that we're going to take into account has to do with tax rates, which is almost always the driver for tax planning and how that affects choice of entities. So there's really two big areas that we see in the One Big Beautiful Bill Act. One deals with individual taxpayers. And what we did with this new act is that we froze in time what TCJA did with tax rates. So the tax rate didn't go up to what it was going to go up to, close to 40%. It stayed at 37% at the top rate. It increased the standard deduction, which affects some charitable planning and other things. Shepherds in a more generous child tax credit, which doesn't affect many of our clients, but it affects our economy greatly, and increases the lifetime transfer tax exemption. That's a pretty big deal for wealthy people. For businesses, the new act included provisions that dealt with the deductibility of state and local taxes. It's a fix that I don't think really fixed a whole lot, because that's such a political hot dog and hot potato. It did continue the immediate expensing of depreciable property, which is a big deal. So when you're putting property into place, being able to deduct it without having to amortize it over a long period of time really changes the economics of those business decisions. And that applies also in 179 deductions. And then probably the last thing that affects businesses, and probably was one of the reasons that the TCJA was so successful, was this new bill makes permanent Section 199A. And so 199A is a real big provision that it came about because under TCJA, the corporate tax rates were reduced to 21%. So individual rates prior to TCJA ranged from 10% to 39.6%. They said that bill set individual graduated rates at 10%, increasing to 37%, with the lower rate schedule to sunset 2025. This sunset was a real problem. People didn't know how to plan for that many years in the future. And we're now in 2025. If that had not passed, we would be going back to where we were before TCJA. The One Big Beautiful Bill made permanent the income tax schedule for individuals and for trusts in the states and indexed them to inflation. So under TCJA, the U.S. corporate income tax rate was also reduced from 35% to 21%. That's the big deal, because you had C corporations that were used to paying basically 35% on most of their income. They had a couple of steps that would pay for some corporations that would pay lower rates. But the corporate income tax rate change is now permanent, was permanent in TCJA, meaning it didn't contain a phase out. And so the OBBBA didn't do anything to the corporate tax rates. And so what that means from a big picture point of view is that if you just look at the law before the Big Beautiful Bill Act, and before TCJA, you had flow-through entities that had better tax rates because the corporate rate was 35%. Individual rates were going to be about that same, but the corporate tax rates with C corporations had to deal with what is a double tax system. You pay tax at the corporate level on income, and then when you pay it out as either dividends or in liquidation, you pay a second level of tax. And so the combined tax rates, if you actually make those distributions, would end up being higher than what you were paying under the flow-through entity. And so it was those kind of changes that when you lower the corporate tax rate to 21%, that kind of changed that whole dynamic, so that when from a tax planning point of view and for corporations that needed to accumulate money to grow or to buy other businesses or to do whatever it is that they needed to do, it looked like it was going to become a lot more efficient for small businesses to be a C corporation. So there was this, hue and cry within the country and in Congress that this is going to really hurt Main Street as opposed to Wall Street. And so actually it was one of those smoke-filled rooms. I remember reading how that played out. But in smoke-filled rooms, a few people, like 4 people, came up with 199A that beginning after years 2017 and before 2026 allowed individuals to deduct 20% of what they call qualified business income with respect to flow-through entities, partnerships, S corporations, or sole proprietorships. They also applied that 20% rate to REIT dividends and cooperative dividends and publicly traded income. And what that did is it put those businesses that could take advantage of the 199A deduction on qualified business income in a position to where their effective tax rate was around 29.6%. When you compare that to the 21% corporate rate plus whatever the tax would be on the double tax on the liquidation or dividends, it put the C corporations and these closely held businesses that could take advantage of Section 199A into a level of parity that really made it easier. And then there's a lot of people that like the flow through entity approach. It's in some ways it's simple, but there's nothing simple about 199A. We used to talk about it a lot because most of our client base that are in that we dealt with are corporate or business clients are closely held businesses. And so that big difference on the rates really made it a whole lot better. And so that is maybe one of the biggest issues that for pro business issues that you're going to see that deals with the new Big Beautiful Bill Act. Not so many small businesses continue to operate. Many not so small businesses continue to operate as flow-through entities. That was an awkward sentence when I wrote it. And so what we see, at least in the Southeast where we are, the flow-through entities aren't just small businesses. Some of the biggest businesses that we have still do this planning. For smaller businesses, 199A is a little bit more friendly. You don't have to go through as much of the definitional issues there for lower income flow-through entities. You get the benefit of the 199A regardless of whether you meet some of the other provisions. And there will be circumstances where owners of certain closely held businesses that need to accumulate their funds will still want to be a C corporation, because if I want to accumulate money and I can accumulate it at 21%, then I don't care about being a flow-through entity because I'm not trying to get the money out. And so it really kind of depends on how, what your motivation is and what you're trying to do with that money.
So would you say the One Big Beautiful Bill Act changed the status quo or more just kept the status quo?
It prevented the sunset from happening. It also changed some of the threshold and limits that made the 199A deduction available. There were going to make some changes, but when it got through Congress, it pretty much stayed, not 100% the same, but pretty much the same. But that would have been a real big problem for closely held businesses if that had sunsetted. Then there's a lot of people in the tax world that I dealt with that had already been toying with going to C corporation status, and that would have pushed them over the edge, because if you're paying if you don't have that 20% tax and your top rate's 37%, it's hard to ever make it make sense to not be a C corporation for those businesses.
Do folks have concerns, even though the sunset's gone, that the corporate tax rate could change in a new political era?
Yeah, that's always a concern. In this yo-yo time politically, it is kind of difficult to think about. But if you recall, the reason the C corporation rate went down so low was the decision that was made in Washington, is that in order to make our country more competitive, we needed to have a corporate tax rate that was lower. I think when it was at the 30-something% level or higher, we were not being as competitive. At least that was the explanation. Now, I think 199A, in terms of our tax controversy practice, we haven't seen a whole lot of audit work on that kind of stuff yet, but I think we will, because you've got all these definitional issues. But the IRS is going to have to get past the things that they love to attack, conservation easements or micro captives or ERC claims. But there are lots of businesses, and it may be this is more of a computational analysis. There's not as many real big factual questions like, are you a specified service trade or business is an issue that's going to come up. And that has been one in certain areas. Like if you're operating an outpatient surgery center, is that entitled to 199A treatment? There's been some case law on that. So that's about definitional issues that can go through the tax court. But the computational part of it is fairly computational. And frankly, when this first came out, it became the issue that I was speaking on a lot and written about a lot. And the accountants of the world that listened to it appreciated that, but I think they're handling most of these issues on a day-to-day basis.
Yeah, and it's like you said, and I think we'll see more of it. Any time you get a new law in and a change of rules, the IRS, from an audit perspective, has to react to that. And what we've seen is they build campaigns and teams to deal with issues. Then they have to educate the frontline people on what to look for in audits and so forth. And so, when you're dealing with an environment where you just don't have those people and you're resource thin, it's going to take some time for these issues to be looked at and audited, I think. And I think we'll see more and more of the IRS failing to move into new areas and focusing on the old ones, unless we have some changes with the staffing, frankly.
Well, and if you look at the partnership tax rules, I mean, there's maybe 5 people in the country that may understand it. A lot of us say that we understand it, but it is so complicated. A friend of mine, Terry Cuff, who's from Los Angeles, really makes a lot of hay about that, saying that we've got all these complicated rules. And if we don't understand them as tax practitioners, he thinks it can't be possible that new revenue agents that come in and have been working for 2 years are going to ever figure that out. Same thing's going to be true in 199A. And so if the upper level of the IRS doesn't have the horses to train their people properly, what you just said makes perfect sense. So another issue that we saw that was really kind of a political hot potato was the SALT deduction limit. Before TCJA, and this was a pay for. This was a provision that took away, and it was really political because I think there were some people that said, we're going to take away something that benefits mostly blue states. And so if we're from red states and we want to hurt somebody, we'll hurt folks with the blue states. But the fact of the matter is the limitation on SALT deductions to $10,000 under TCJA really hurts a lot of people, but you've got some states like New York and California that have higher state and local taxes, and that affects those folks dramatically. There were workarounds in about 35 states that allow state and local taxes that are attributable to flow through entities that are related to business to allow the deductibility of that. And I'm not sure where that's going to all end up at the end of the day. But OBBBA addressed the SALT issue as politically, there was a lot of people from a lot of states that wanted to raise that cap. They negotiated, they wanted to make the cap go away. There's a lot that has been written in this area, and I'm not going to add a lot to the literature today, but they ultimately came up with a cap that went from 10,000 to 40,000, but to the extent a taxpayer's income level exceeds $500,000, or for married filing jointly, or $250 for married filing separately, it phases out so that once your income gets up to $600,000, the benefit of that phase up from 10 to 40 really just kind of went away. So I don't know that we've seen the end of that, because it is, for people in Alabama, we have lower property taxes, we have income taxes, and anybody that makes any amount of money is going to get over that threshold. And so it really doesn't, it changes a lot of issues, because it changes the ability, you've got these state and local taxes that would in the past shelter the income. And interestingly enough, for state purposes, these rules don't all apply. So if you're looking at the state income tax deduction for federal, or for interest or other things that have federal limits, it may not apply. So it just kind of goes from a state to state issue. I think just in the interest of time, the last big thing that I wanted to talk about, and there's several other issues, and if y'all have got this PowerPoint, we added more than we knew we could possibly carry, is the Big Beautiful Bill Act introduces changes for founders and investors in domestic C corporations that hold qualified small business stock. So really what this is, in 1993, the Congress enacted into law Section 1202 of the code. It was a new Section 1202. And what it did is it allowed people to invest in C corporations for original issued stock. It had to be in a domestic C corporation, and the corporate's aggregate assets were limited. They couldn't exceed $50 million. That's cash and assets used in the business. And the stock had to be held by the taxpayer for more than 5 years. And what that would allow you to do if you met all these requirements, and they were not easy to meet, but they could be met. If you were a C corporation, what that allowed you to do was exclude a bunch of the capital gain on the sale of that stock later on. So the amount of there was a 5-year holding period, and in section 1202 had a couple of gain limitations so it could only apply to a certain amount of gain. And there was a cap. And for stock issued prior to July 5, 2025, which is the effective date of Big Beautiful Bill, eligible taxpayers were permitted to exclude gain with respect to a single issue up to these limitations. The Big Beautiful Bill increased the amount that a taxpayer may exclude from capital gains on a sale of the qualified small business stock. So that for stock issued after July 4, it has to be an original issue. You can't buy it from somebody. I can't sell stock to you, Greg, and let you take advantage of it. The taxpayer can exclude the greater of $15 million, and that's now adjusted for inflation, or 10 times their investment in the stock. And so this is one of those things. I ran into it a few times in my practice where people had operated a C corporation business for a few years. They went to sell the business, and lo and behold, we look at it and we say, oh, we could qualify. And so it's not often, it's one of those things that you can plan for, and it can be very beneficial. But you've got some different rules that are in there. The Big Beautiful Bill Act introduced a tiered required holding period. So you no longer have to hold it for a full 5 years, but you have different percentages of the gain that you get to exclude depending on how long you hold it. And there's an ability to roll over some of the gain into another qualified small business, and that helps solve your holding period requirement.
So it's a really helpful provision. And if you go on the IRS's website, they've actually looked at this over time and said it's an area that they really kind of want to focus some audits on. We actually had one. And for the people listening, I think it's pretty important because, it's a document fact intensive, elements you have to prove with this. And it's not only on the individual side, the corporate side as well has some requirements. So, we'll talk about it in a minute, but this is one of those areas where retaining the documentation to be able to substantiate the position is going to be pretty important. And it's not, it's one of those issues that the taxpayer may not have and may need to rely on the company for.
It can be so valuable because you can really exclude a lot of the capital gain, and then whatever's left is capital gain. But what you said, Greg, you got to maintain these records, and these are big businesses. You can have aggregate gross assets in the business of $75 million now to start off with. And so when you sell that stock for big gains, that can really save a whole bunch of money. I'm going to hand this over to Greg. The rest of the outline talks about changes to the Qualified Opportunity Zone program, which is very useful. But we don't have time to deal with it. And then some of the business tax incentives, the 100% deductibility of depreciable property, instead of having to amortize it. And then also a mention of the changes to the estate and gift tax rules that affect many of our business owners as opposed to others.
And then on the opportunity zone, since we're skipping over it, that's worth mentioning that, a lot of people have taken advantage of that. That's another one. If you look at, the IRS website and the IRS guidance all the way back in 2022, the IRS had done a study and kind of went through all the documentation that was filed on these and found that there was a lot of errors, and these are real large money type things. And so they prioritized a campaign in this area. And then the new bill kind of put some more disclosure requirements and then strengthen the penalties in that area. So I think it's an area that we're really going to see a lot. Assuming we still have an IRS enforcement activity going on, it's an area that I think we'll see a lot of activity.
The ozone also is going to change its focus to more rural development. And so we will see an awful lot of different opportunities. And so we've seen a lot of our clients get involved in these funds. And the fact that this has been made permanent instead of it was really kind of scheduled to wind down about now, that's really going to be a lot better.
Yeah, and that was a good vehicle that a lot of people used to develop real estate development, really prompted a lot of real estate development, and a lot of downtowns have become somewhat blighted. So it was a really useful tool. And now that it's permanent, I think we'll see, like you said, Ronald, it expanding to the rural areas.
And importantly, because I assume some people are listening to the tax presentation to get their CLE, I have been requested to tell you that, as mentioned at the beginning of this webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, Pennsylvania licensed attendees must type code word tax into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is tax. All right, so now that we've talked about the big beautiful bill and a combination of that with all of these IRS disarray and cuts and lack of kind of a lack of a team to prosecute cases, the question becomes, what in the world are we as, in-house counsel or lawyers supposed to think about this? I think it's fair to say that, as pretty much all bills do, the big beautiful bill probably in the aggregate only increase the types of goodies out there. And so, kind of create some fiscal issues. So we're going to need to collect some tax, but at the same time, it doesn't look like we have a real good enforcement funding to do that. And so, unless we're going to count on all the tariff money, which also is a little bit in flux, what's going to happen now? And
just to be balanced, I think there's a good chance that these pro-taxpayer, pro-business bills will grow the economy and grow the revenues of the government, which has been historically there. But that's a political issue for some other people to talk about.
And so then, we've had a lot of clients that said, well, given what's going on with the IRS and so forth, do I need to file tax returns? Should I be more aggressive? And not joking on the tax return, but I do think there's a perception that people can be more aggressive. But there's no doubt that there's some cuts across the IRS spectrum. But when you look at this, which is June of 2025, and this is certainly changing, you'll notice that the areas that have the least amount of cuts are like Chief Counsel, IRS Criminal Investigation Unit. So we do, although there's cuts there, they're not quite as dramatic as in the area of appeals, which resolves cases, online services, which, as Michelle mentioned, is quite frankly kind of surprising to me, because that's kind of a way we thought they were going to streamline things, but also things like taxpayer experience officers. Anecdotally, they're also cutting the taxpayer advocate service. These are all places that really try and help get issues resolved instead of really prosecuting cases. So I think, there's certainly going to be less enforcement to some degree, but really I think the biggest problems and the cuts are going to become in the taxpayer service areas, which may kind of have the reverse impact that some people were anticipating.
And just wanted to say, as far as aggressive, IRS funding is cyclical. So its funding was really high under Biden, which is why all these divisions got beefed up. Now it's very low. It's going to be high again. So I heard another tax lawyer say the best time to file an aggressive position would have been two years ago. Because the IRS will have 3 years to audit your tax return. And so by the time they get around to auditing it, we might be in a new funding regime. So now is not necessarily the time to take an aggressive position.
And that's true. And then Michelle makes a really good point too. This all happened in just an instant. We saw this area where all of a sudden it looked like the IRS was going to be the largest unit, really beefed up, and then the next day it was all of a sudden it was moving in the reverse direction. And so, no one can predict tomorrow, but I do think it's safe to assume, for at least in the interim, we're going to have some issues with especially kind of taxpayer service. And so what does this mean? Plan for delayed refunds. Assume that tax refunds, credits, ERC, other type of credits, they're going to take longer to arrive. Some businesses rely on these funds. And so it's great to tell you, be aware of it, but what can you do? Probably one of the most effective things you can do, which I think a lot of people are doing, is if you have the ability, do not file with paper. File electronically. The IRS has a website. You can do most things electronically. You can order transcripts. You can check your transcripts. They've got a Where's My Refund tab on there. So you can do a lot of this stuff electronically, but certainly if you can file things electronically, do that. The IRS says right now, e-filing, it takes them about 21 days to process. Filing things by paper are an average 6 weeks before they're processed. So that's a basic thing you can do. Also, and can't stress this enough, respond quickly to notices. The IRS sends out notices, and if you don't respond, the one thing you can say about every IRS notice that comes out essentially is it has a deadline to respond. And we have seen time and time again, taxpayers not respond by those deadlines. Those deadlines are really all or nothing. And once you don't respond to one of those deadlines, it just creates this system where all of a sudden penalties are asserted, penalties are coming out, and there's really no way to get back in front of it. It used to be easy to go to the taxpayer assistance, and they could help you kind of unwind the mess, but we went down there, we had someone go down there the other day, and they basically just said, I mean, they're not supposed to, but we are not taking on new cases. And so that's a reality right now. So it's very important to take these notices and respond to them quickly. Again,
And just an important point, we've seen recently a lot of notices not going to the power of attorney. And so you got to be really careful. What we've seen, especially with the lack of service, is that, they might have the wrong person tied to the account. They might have the wrong address. You got to make sure you might have changed your address and haven't filed something with the IRS to let them know. And once that notice goes to the address on the tax return, the IRS is starting its clock. So something you got to make sure is that all your addresses on all your IRS filings are correct, because the notice, that's the only place they have to deliver it. They're not necessarily going to give it to your power of attorney. And we also learned that even though notices are supposed to appear on the portal, there's a tab for notices. We talked to a revenue appeals officer the other day who says they don't upload all the notices to the portal. So the mail notice is what they consider their best and final, and you're not necessarily going to receive any other copies of it.
One thing you have to worry about sometimes, you get a notice that's dated, October 8th.
Yeah.
Doesn't get to you until October 20th. And there's no way they send it out on the 8th, but that's the date of the notice, and that's the date that they look at their time limits. And so that's I've seen that happen a lot lately. A lot. And that's something. So when you got to open your mail, you can't just let it sit on your desk and get to it once a week.
Yeah. And then on the electronic tools, although it's great to file things electronically, obviously we heavily encourage that. We've had some clients lately that have filed things electronically, under the assumption that if they're filing electronically, well, the IRS certainly has to have proof of the filing and putting it in the file and so forth. We've had payroll instances and other things where things were definitely filed, but once they filed it, they had no proof on the client side. And then the IRS just said, well, we just didn't get it. And so I'd encourage you to, whatever you have to do to document the filing and not just rely on the fact that because it was electronic, it was there. And then this gets back to the documentation. Can't stress enough, all of us fall into this trap of doing a filing, getting it done, and moving on. But the documentation is critical. It is the first line of defense with pretty much every tax position you take. These audits take forever. And certainly, we go to court a lot. And so most people aren't going to have to be in that position. But if you do, by the time it's actually getting litigated, you can be, 7-10 years down the road. And so it's really important to have records, that will prevent you from getting to that point, But if you do get there, it's kind of how you substantiate your case.
And if you have an inexperienced auditor, now that the IRS has lost so many people, well organized records, well presented information is going to make the audit so much smoother than if you just dump a bunch of files on the IRS agent. They're gonna want to work with you because they don't know what they're doing.
And we've always seen that, they are
Yeah.
humans too. And if you make their job easier, they're going to make your life easier. And that's only going to become more so as they become more overworked. I mean, we talk with them all the time, and there is a little bit of a feeling of, I guess, feeling down now, for lack of a better word. And if you can work with them and make their job easier, they will appreciate it. Embrace conservatism. This is kind of where we were before. The IRS is definitely resource strained, but they also still need to raise revenue. And what they are going to do is, we've seen before, is go for the bigger bang for their buck. And these are items like tax shelters and those things that have to be reported, things they can easily pick up, things they know they've got a good position on. And so I certainly would not embrace the idea of, oh, the IRS is, resource constrained. Let's really push the limit. It's really not a good idea. It's counterintuitive. One of the things that we're seeing that we've always done, we've always recommended, but is certainly going to become even more important now, is obtain and monitor your business transcripts, your tax records. So you can go on to the IRS website, and it's www.irs.gov/business. And there's all kind of resources there for businesses. If you go on to the business tax account, you can actually get on there. Some people will hire an attorney, a POA, to monitor it. But monitoring that is incredibly important. It relates, sometimes the IRS is not getting notices out to the places it says it's getting out. Sometimes you'll have an employee that doesn't know how to deal with them. And once that mess starts and you don't catch it early, it becomes a nightmare. And so the only way to reliably know that that's not happening is to check your transcripts. And that's something we've always recommended, but again, some of these things are becoming more and more important. This is, another thing when you're documenting things, keep your business records and personal finances separate. This also applies to people that are running multiple businesses. You really want to keep the accounts separate. It helps not only with the returns, obviously, but also with the substantiation if an audit does happen. And one of the things that I learned from a trial I just had that's very important, if you do this, and we recommend doing it, then follow through with it. So if you have a business account, and use it for business. If you have a separate non-business account, don't put business receipts in there. We actually had a client that was engaged in business and was getting a large amount of cash, and he was putting it in his personal account because he didn't think anything of it, not his business account. And his business account was being filtered through QuickBooks, and thus arguably the return. So the IRS took the position that that's fraud, because once he established the separate accounts, he should have respected them. Again, I don't think it's a good argument for the IRS, but it's just a position you don't want to be in. And I think one of the last things to mention that we've never really recommended before, but we have seen some clients use, is there's audit protection and tax protection. So these are kind of two different policies. One, you can get a policy that if you do get audited, that will pay for your representation in the audit, and that can be different policies, either your own person or they'll designate someone. And then there's also tax audit protection for the actual tax. That's kind of a different animal. It's more expensive, it's more complex, but it can actually protect you if you are audited, and then they would assume the risk of any payment. but that can also lead into reportable transaction types issues. So if you decide to go there, there's a lot to consider. And so I think we're out of time. Did y'all have any final comments before I read the final statement here?
No, we appreciate y'all having us. I think that in this time of change, paying attention and giving the resources that you need to keep up with it is really essential, whether it be planning or for protecting yourself in audit.
And then they have asked me to provide a closing remark. Thank you again for participating in today's CLE webinar. In approximately 30 days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. Have a great day. Thank y'all for joining us today.